Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for February 28th, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Marufo, would you call our next case, please?
Middle of page 21, Judge. Annex, may we have Rafael Silva?
Yes, sir. Give me 1 second.
Good afternoon, Your Honor.
Good afternoon, Ms. Nava.
Good afternoon, Judge. I couldn't hear earlier. I apologize if something was said.
Okay, no, we're just on Mr. Silva's case.
Okay.
Good afternoon, Your Honor.
Hi, Ms. Caro. Is this one where we were going to get a plan squared away? We had a reset. Okay, we're ready.
Yes, Your Honor.
In cause number 2014-0D04998, State of Texas versus Rafael Valenzuela Silva. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
Alyssa Nava on behalf of Mr. Silva, Your Honor, and we're ready to proceed.
Cynthia Caro with adult probation, Your Honor.
And for purposes of the record, Mr. Silva is appearing from the jail annex. We had a reset to maybe look at some, I guess, unique issues in Mr. Silva's case. I don't know, was Ms. Caro or you the primary contact on that, or were we working with someone else?
Your Honor, yes, I've been working on this for a couple of weeks. I sent you a summary, Your Honor, but the date changed, so I wanted to just kind of go over the plan again.
Okay.
On March 2nd, Mr. Silva has an intake appointment with Takumi at 2 o'clock in the afternoon. So with your court's permission, we would allow him to be released from jail at 12:30, and I would pick him up and take him to his Takumi appointment. And he has the appointment with Dr. Moreira, which is his psych doctor at Takumi, at 3 o'clock. So on that same day, he can leave with his medication. And then the plan is to have him reside at the rescue mission until the Takumi caseworker can start working on his case and hopefully get him SSI.
Okay. Let me see. Ms. Elizalde, do you have any input?
No, Your Honor. I was also under the impression that everything, that probation was really working with Mr. Silva, and that we were going to follow that route.
I'm sorry, my computer froze. Would you please repeat that? I was under the impression.
Oh, that probation was really working with Mr. Silva, and that's the route that we were going to go. And I don't see any new arrests or anything like that.
Yeah, there's a huge amount. When does he go back to the report? I'm trying to do everything on one screen here.
So he was sentenced in 2016 of February, so in 2026, and I don't know if he's been modified. I don't believe so.
I guess I want to understand a little bit about what he'll be doing on probation. Will we have him? How often will he be reporting? Obviously, I know he'll have to be compliant with all mental health treatment and meds, but how? I want to make sure we don't lose track. And so, Ms. Caro, what can you tell me about that?
So I am concerned about losing track because I personally lost track of him a few years back. So I'm very wary about that. But he will be reporting to me on a weekly basis to the downtown office. And I will pass by through the downtown office before we take him to the rescue mission to ensure that he knows where he needs to go every single Tuesday. The reason I'm picking Tuesday is because sometimes there's a holiday on a Monday, but this way there's no confusion. It's every single Tuesday. Your Honor, he does not like to stay in homeless shelters. I've known him for a long time. He'd rather sleep in the street by himself than around other people. But we did talk to him. His aunt talked to him and advised him that he needs to stay there because it's what we're asking him to do as part of probation so that we can eventually work on his case to get him out of the rescue mission and into maybe a group home where they can provide 3 meals a day and a clean environment. That's my goal for him, Your Honor, for as far as probation is concerned. I want to see him stable. I want to, him taking his medication, him having a better place to live. That's not a shelter.
Ms. Nava, have you had a chance to, I think Ms. Gatto is being very kind in terms of saying, Mr. Silva, we are asking you, please, pretty please, will you please stay at the shelter while we make some accommodations? That is not what is happening. Obviously, Ms. Nava, you know that. Those are orders. In other words, Mr. Silva, you are being ordered, or you will be ordered if I am going to release you, to be at that homeless shelter until they can find other accommodations for you that may be better. But I have a lot of concerns, Ms. Nava. I really don't know, other than having the weekly reporting, that we can assure that, there's a long pattern, and there's a long pattern of losing track of Mr. Silva.
Correct, Your Honor, and I did speak with Ms. Gatto earlier today, and I let her know too that I was going to reinforce with Mr. Silva that he had to stay at the shelter if that's what the order is going to be. I think as long as he is stable and on his medication, he will comply. But I think that's where the issue comes, is when he is not on his medication.
Yeah. What was the type of, if he was with you, Ms. Gatto, I got to think he was on a similar kind of a mental health intensive probation before, right?
He was, Your Honor.
Yeah.
And he did very well for a little bit. And he knew he had to come report, but then, the schizophrenia kicked in and suddenly I was a suspicious person, and then he stopped reporting to me. And because he doesn't sleep at shelters, we had a really hard time finding him. We couldn't call a shelter or go to a shelter and find him. He was in the streets. So we lost him for a long time. And yes, that is still a concern.
Yeah.
But I'm hoping that if the doctor puts him on medication right away, then he takes that medication and hopefully will be okay. But of course, Your Honor, it's up to him.
Is it, I'm not sure in terms of how cooperative the shelter is. Is there a way to confirm that he's staying there? Will they, like if you're able to check in, so he's reporting weekly, which in any other situation or many other situations is frequent and would certainly go a long way to alleviate the court's concerns. It is not quite doing that in this circumstance. And so is there a way that probation can call up rescue mission mid reporting and confirm that he's there? Will they give you that information, or is it something where you would have to actually either go check in on him or anything like that?
Your Honor, we can have him sign a release at the time that I take him so that they know that I'll be calling. And what they do is they have a check-in. They check him in at night to make sure that they can account for him. And if he's not there, they will call me.
Okay. Well, that's kind of the supervision that I want on Mr. Silva. Okay, so Ms. Nava, you may want to explain to your client the issues with the release if he has those kinds of questions. But Mr. Silva, the order, in order for you to be released, is going to be that you reside and you at the rescue mission and you report weekly. You also will be participating in all Takumi services and any other mental health treatment that comes from that. If probation or Takumi or anyone else is starting to recommend supplemental mental health plans, it is the order. In other words, your conditions include, the conditions of your probation include all of those things, to include taking this medication. Will also require that probation be allowed to communicate with the rescue mission or any other shelter he is in providing information about him actually residing in those particular shelters. Okay, so if any of those things become a problem, we can come back. I will not make the modification, Ms. Nava, until you have been able to have a thorough discussion with Mr. Silva.
Yes, sir.
I do not, I'm going to reset it for 2 weeks with the idea that we will hear from you, Ms. Nava, about whether we have a problem or not. Okay,
Yes.
if everything's good to go, then Ms. Gatto, once we have that confirmation, then we will move forward with that plan. I then will have a probation status hearing 30 days after he's released. Okay,
Your Honor, would you like me to reset the appointment for 2 weeks from now, or do you want to discuss it first and then reset it?
I don't know how quickly, so the second is what, Thursday? Is it Thursday?
The second
Yes.
is this Thursday, Your Honor.
Ms. Nava, you think you can do something that quickly?
Your Honor, I can get out to the annex tomorrow, maybe.
Okay, if you can do that and let us know today, then I think we can get him released in time for that appointment, no? Ms. Caro, do you know?
I think so, Your Honor. If you can get a release detainer to release to me at 12:30
Okay.
on
Okay,
March 2nd, and I think that'll work if we can speak to him prior to that.
I'll have that ready to go as soon as I hear from Ms. Nava.
Thank you.
Actually, Your Honor, is it okay if I go tomorrow first thing in the morning?
That's fine. I was also going to tell you, if you have time, we have a very busy docket today. I don't have a problem giving you a breakout room, but I don't know if you have time for that. So I
Yes,
didn't want
Your
to
Honor.
hold you to that. Okay.
I can
well,
do that.
All right, let's do that. All right, Mr. Silva, they're going to bring you back after we're done with the rest of the cases. So Ms. Nava can speak with you about what we're discussing today, okay?
Yes, ma'am.
Thank you. Okay, let's go. Thank you, Ms. Nava. Thank you, Ms. Caro.
Thank you, Your Honor. May I be excused?
Thank
You
you.
may, yes. Okay, who's next?
Third one on page 20, Judge. Annex, may we have Benjamin Contreras?
I did see Mr. Hughes here, and I saw on the docket, Jacqueline Johnston, is she in custody?
Yes, ma'am, she is.
Okay.
She got, we had a deal on her first case, this,
Mhm.
dated in 29/31, which signed the plea papers. She got picked up on a new charge, and that's pending action by the grand jury.
Okay, I only have us down for a status conference, and it didn't say on the docket that she was in jail, so I was worried. I didn't want you here if you didn't have to be here. But we just have it for a status. Is that case already set for trial? The forgery case?
No, ma'am, it was going to be a plea.
Okay.
We had actually signed the plea papers. Ms. Johnson came to our office to sign the plea papers, and before the plea, she got charged with a new offense, a P-file case. I believe it's a drug offense, and it hasn't gone to the grand jury as of yet. I don't know. Maybe the DA can tell us more.
Okay, well, I'm happy to keep you here, Mr. Hughes, on the status conference. We do have a jury trial on that case on April 21st, and we have our final judges conference on March 7th. Did you need to approach the court with your client on something?
No, ma'am. Well, we just need the new case filed.
Okay, all right,
Because we had already signed the plea papers on the pending forgery case.
okay.
Judge, if I may, I have a U.S. assistant attorney reach out to me on the new case, given the amount and the type of drugs in there. So this is not going to be, your usual drug case that we deal with. And I'll speak to you, Mr. Hughes, about it and what they're talking to me about. Okay.
That's fair enough. When you get around to it, give me a heads up. Jacqueline's in jail. She can't make bonds, so she's not going anywhere.
Okay.
And if it's okay with you, Mr. Hughes, I just assume let you all go to your final judges unless you need to have her here in front of me.
No, ma'am, she doesn't need to appear in front of you. We just need to, I don't know anything about the new case, and now there's an indication that the feds may be involved. So
Okay.
I'll have to vet that and see what's going on.
Okay, then if you're not needing to go on the record on this one, then you're good to go.
Okay, thank you, Judge.
Thank you, Mr. Hughes.
To my friends in the DA's office, I'll see you guys later.
Take care. Okay, Mr. Contreras, go ahead.
In cause number 2021-0D01785, State of Texas versus Benjamin Contreras. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Daniel Leveler for Mr. Contreras.
Mr. Contreras is appearing from the jail annex. We were set for probation status hearing. I thought we were at 2 TDC and like just waiting to sign him up. Was there something else going on?
Judge, yeah, I think Mr. Contreras wants to retain different counsel or something like that. Mr. Contreras?
I haven't talked around with my counselor that paid for it.
Are you court appointed, Mr. Avalar? Or is
No, we are retained.
okay. So, I mean, we're here at a probation status hearing. Mr. Contreras, are you hiring a different attorney?
No, I hired Underwood and I've never spoken to him yet.
Okay. So I don't see anything in terms of a motion to withdraw. I don't know if Mr. Underwood's available, Mr. Avalar, but I mean,
Do you need
the only thing I'm going to do is I'm going to put you on a revo track at this point. We're going to go in 30 days. We're going to go for a pre-revo hearing. And 2 weeks after that, revocation hearing.
Can you repeat that last part?
30 days pre-revo.
Okay.
And then 2 weeks after that, if you all want to contest it, we'll contest it.
Yes,
Mr.
ma'am.
Contreras, if I'm not going to get into the details of I don't know if you're having issues with your attorney, but I am resetting you to put you on the revocation track. Up until this point, I thought there was at least some agreement on, I think the state had offered 3 TDC. I indicated, and I'm not sure if Mr. Underwood was here last time, that we would, the court would accept 2. I think it was Mr. Underwood, actually. Mr. Underwood was here at the last hearing.
Yes,
And
ma'am.
so you'll have your settings, okay? All right, who's next?
Then on page 20, top of page 20, Judge.
Mm-hmm.
Annex, may we have Cardona?
What was the name again, sir? Cardona.
Cardona.
Afternoon, Judge.
Good afternoon, Mr. Anderson. Marissa, did I already ask you about Cardona's bonds? If not, I'm going to need them.
No, Your Honor, but let me get those for you.
I was not able, I kept searching for bond amounts. And Mr. Anderson, in searching for bond amounts, I think I stumbled over a whole bunch of JMAGs, JMAG new cases. So I kind of just stopped looking for bond amounts at that point.
Yeah, I think there's only 2 cases in front of you. They've both been indicted.
Right.
And I can tell you that my understanding is that on the drug case, the bond amount is $150,000.
I have that one. Mhm.
And then the other one was indicted as a stalking. I believe that one's $25,000.
25,000. Okay, that's the one.
That's correct, Your Honor. That's a split bond. The cause number ending in 528.
What's the split, Marissa? And if you have the bond order, will you email it to me, please? I was having a lot of trouble, but I was getting a little bit confused with all the JMAG cases. So let's get started on that one.
Yes, I'll email it right now, Judge.
Thank you.
In cause number 2023-0D0-0528 and 2023-0D0-0443, State of Texas versus Wilfredo Cardona. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready. Also appearing for Mr. Preston on the possession case.
Preston Month is here for the state on
Oh.
2023-0D00443.
Right.
Greg Anderson on behalf of Mr. Cardona, ready to proceed, Your Honor.
And Mr. Cardona is appearing from the jail annex. We're scheduled in both of these cases for bond hearings. Mr. Anderson, you may proceed.
Your Honor, may I, can I address the cases in whatever order I want, or did you want me to specifically address the stalking one first?
No, you can address them. Just tell me in whatever order you want. Just tell me what you're talking about.
Okay. Initially, Judge, I want to tell you a little bit about Mr. Cardona. He served honorably in the U.S. Army here in El Paso between the years, I believe it was 2012 to 2015. During that period of time, he was, I think, in the medical care patients administration unit. Afterward, when he was honorably discharged in 2015, he went to school, and I think he has ultimately received his master's in business administration. During that time and since that time, he has been involved in many administrative posts, mainly involving the administrative positions involving janitorial type positions at hotels. And in fact, I think in the year 2020, he was the director of the janitorial staff over at Hotel Indigo. Prior to that, he was involved in various positions involving administrative positions in various hotels and the like. And then even while he was at Hotel Indigo here in El Paso, he opened up various small businesses and conducted those. He's a very industrious young man. In 2021, I believe it was, he moved to Boston, and he was basically the head administrator of the janitorial section of a hotel in Boston, Massachusetts. In 2021, I believe it was, DPS reported that they had made a buy from him of some narcotics. I believe that was in April of 21, but I may be wrong about the date. I think in August or thereabouts, they indicted Mr. Cardona, and the detectives reached out to Mr. Cardona, who was living in Boston, Massachusetts at the time. Mr. Cardona voluntarily returned to El Paso to turn himself in, and that's exactly what he did. He posted a $50,000 bond on that drug case. And stayed here in El Paso despite the fact that it's now been a year and a half. And as far as I can tell, the drugs have not been analyzed by any drug lab, and that's why there was such a delay in the indictment taking place. During that period of time, he faithfully reported to his bondsman, and he always stayed in contact with me, and he was attempting to open up very small businesses here, even though that drug case hanging over his head was, I can tell you, was had quite an impact upon him. I don't think I need to talk about in detail the facts of that case, but I do argue with the fact that when they indicted the case, they raised his bond up to $150,000. I think what happened is when these new cases came up, Your Honor, and I'll address those in a minute, the bondsman surrendered his bond, which he had paid on the $50,000 form. I'm requesting on that case that the bond be reduced from $150,000. Honestly, I'd like to see it reduced to a PR bond in light of the fact that he basically was posted the bond, and then once all this came up, it got forfeited and the bond got jacked up. On the stalking case, what happened, Judge, is as you can imagine, it is a custody dispute in effect. And Mr. Cardona is in the midst of a custody dispute. I do not represent him in that case. I'm not involved in the family law case, but I have reviewed the paperwork which was sent to the DA's office, which in effect supports the charges that were brought against him. Basically, what was going on is he was fighting over custody with his wife, his ex-wife, over their 8-year-old son. He was sending some text messages to both his ex-wife's attorney and her, as well as emails. They did start to get a little bit belligerent, I will say that. Not terrible, I don't think, but at least belligerent. Because at one point in, I think right around December, maybe January of this year, custody was cut off to him. And so he started getting a little bit belligerent about why were they keeping him from having custody and stuff like that. On the portal, there are many text messages and there are many videos, including ring videos of where one ring video where my client went over to his divorced wife's house and knocked on the door. He made no threats. He never raised his voice. His wife poked her head out the door and said, "Please leave, Wilfredo." There was nothing aggressive done there. I will tell you that the only thing I've seen that is at least slightly aggressive or arguably aggressive are texts apparently where apparently she had gone over to his house and was apparently yelling. I don't know if that's true, Judge, but that's what the text to her was, saying, "Quit coming over to my place and yelling. And if you threaten me, I have a gun here and I'll protect myself." That's the only allegation I can see that is at least arguably a threat of injury. I will say, Judge, that when the police officers got involved in that particular case, they brought it to the DA's office as just a harassment case. And I think it's because of the multiple texts that were going out and things like that. I can't 100% say that my client did not threaten the complainant because I wasn't there. I know that the videos that were supplied by the complainant did not have any threats. So to me, I think what the police department who investigated the thing intended that what would happen in this case is that he would be charged with harassment for sending multiple texts and things like that. Somebody at the DA's office dug into it deeper and I guess thought that it was worse than what the police officers thought, I guess. And that's why it was filed as a stalking. Initially, it was intended to be filed as a misdemeanor and it got bumped up to a felony. So, Judge, I'm not saying that, and the other, do you want me to address the other stuff? I had bond hearings on the other stuff in front of Judge Nunez, who basically granted various split bonds, PR bonds, and things like that. And
What I know in terms of the bond amounts there, as I was mentioning earlier, in trying to figure out what the bond was on the stalking, I was going through the jailing and seeing all these other cases. And so I did see the bonds on some of those JMAG cases. I recall seeing a harassment, and I'm not sure I'm understanding that the harassment is this stalking, but I'm not sure, so I'm not really going there. What I would like to know, though, with respect to all of these cases, to include the JMAG cases, is in order from the ones that I have, meaning the drug case and the stalking case, and then going to the JMAG cases, I want to know dates of offense, alleged dates of offense. That's what I want.
the stalking case, I think from looking at the complaint that was taken to the DA's office, all of the allegations for January of 2023. And it was just 3 or 4 days where they noted in the affidavit that he was sending harassing texts and things like that. And he went over to her house on one occasion, possibly 2 occasions. All of those happened in January of 2023.
And the drug case?
That was, I think, April of 2021.
2021. Okay, and then I have, in terms, I don't have, but what I saw was a theft of a firearm, a UCW. Oh my God, I can't read my writing. A harassment, an AFV impeding. Do I have those right?
I think so, Judge. Those are completely different cases. And I think, I don't know the specific dates, but I'm assuming those were also in January of 2023, but I'm not 100% sure about that.
Okay.
Those involved, do you want to know just kind of thumbnail sketch of what the allegations are?
Well, in looking at trying to decipher if that harassment was in fact a stalking, because I was thinking the same thing you were, I think I have a general idea. Since I'm not really going there in terms of the substance, I just wanted to know alleged dates of offense. So
I think those are January 2023 also. And one of the harassments that you see in the jail log was what is turned into a harassment. So I'm not, and maybe I'm not 100% sure on how that works. I'd asked the jail mag to kind of walk through with me on that. We were too a little bit confused. But I think all of those were 2023 January cases as well.
So I think, Ms. Nieto, if I'm reading this chat, is that there are two different cases. So we have one that is a stalking, and then we have a separate JMAC number for another harassment.
Judge,
So-
I think that involved a different complainant,
Mhm.
a girlfriend. Not
Right.
even a girlfriend, somebody who actually, he moved into his place and very quickly moved out.
Okay, well, I don't really want to go too far into those that I don't have here. I just did want to have an idea in terms of activity, alleged activity, what type of dates we were talking. What else do you have, Mr. Anderson?
I believe that's it.
Okay, well, I don't know who's gonna go first. Ms. Elizalde or Mr. Munson, who's handling the bond hearings?
I can go first, Judge, if you don't mind, Mr. Munson.
Go ahead.
Judge, I think that opposing counsel's version, while not incorrect, does not tell the whole story. I am glad and I absolutely see why our office charged this as a felony. The defendant and the victim do have a custody order, and that was the source of the issues, I believe. The defendant went to the victim's house. He kept banging on the door. She opens the door, leaving a little room for the security chain on the door, and tells him to leave. He said, "I need to see my son." On another day, he then showed up to the church. He does not attend that church, and he took his son out of the class for 5 minutes. It appears there's video of both incidents. And then on January 14th, the defendant called her and told her that he got his gun back, referencing a dismissed case, an aggravated assault with a deadly weapon that was dismissed in 2019. And he let her know that he got his gun back. Now, on January 21, the defendant went to her home and began banging on the door. He attempted to open the door, and the incident was again caught on the Ring camera. The defendant then began texting and calling the victim and her mom. And so in summary, these are what the messages show, which is, and I want to be very clear, because we have this thing where we're saying, oh, he's a little bit of aggressive, but in no way should this behavior just, go saying he was just a bit belligerent. That's not what this was. He says, "I have 70K in the bank. I will have your ass. I will show up at your church and arrest you." He posted a video in front of the victim's house saying she should be scared. "My demands must be met if you want to see your son. If you want to see your son again, you will have to give me 50-50 custody." Now, his record, the aggravated assault with a deadly weapon that was dismissed was same victim. The VPO in 2020 that was dismissed was the same victim. And now, of course, we have the same drug case. But I think, Judge, what I'm trying to convey is the severity of his behavior. It's not just belligerent. He represents a threat to this victim and as such to the community. And I would argue that bond is reasonable, given this serious nature of the allegations made here.
Okay. All right. Was Mr. Munson, that was on the stalking, right? Mr. Munson, are you handling the drug case? Is that how?
Yes, I am. And I'll be fairly brief because Ms. Elizalde covered most of it. My main concern, normally I'd, with the bond as is 150,000, I'd be willing to agree to some reduction on this type of drug case, but considering the cases he's now picking up, I'm concerned for the safety of the community beyond our Mandel, which right now is a minimum of 5 years. So at this point, Your Honor, I request that the bond remain the same.
Okay. Anything else?
No, I
Nothing.
don't think so. I don't think so, Judge.
So no, the request for a bond reduction is denied based on the safety concerns, non-compliance. There's just way too much happening here with Mr. Cardona. So some, not all, but some of those JMAG cases should be coming here, Mr. Anderson. So because, am I wrong? There is an A and B impeding in that bunch, correct?
I don't see it yet, Judge, but it should be coming. If it's an F3, so it would end up here.
There was quite a few entries in the documents with all of these cases. And so it was hard for me to figure out, and I can't write legibly, so I couldn't tell you that if I wrote everything down, but no, the bonds are going to stay the same. Absolutely. Thank you very much.
Judge, may I ask you, are you saying that you're not going to reduce the drug bond either?
Correct. I think both bonds are appropriate.
Thank you all.
Okay. But because I know we're gonna have more, I have a feeling we're gonna see you again on the bond, Mr. Anderson. So as soon as we get those, you know, we'll address them.
See you soon, Judge.
All right, take care. Who's next?
Middle of page 21, Judge. Annex, may we have Mejia, Mario Mejia?
Yes, sir. Give me 1 second.
Good afternoon, Your Honor.
Good afternoon, Mr. Parra.
Yeah.
Afternoon, Judge.
Hi, Ms. Parra. All right, Mr. Mejia, go ahead.
In cause number 2013-0303853, State of Texas versus Mario Miguel Mejia. Announcement of council, please.
Again, Elizalde for the state. State is ready.
Manuel Parra, Your Honor, Mr. Mejia, also ready.
Mr. Mejia is appearing from the jail annex. We are set for a probation status hearing today. This is definitely an older case. And I think, is this one of the ones we did our review on, Ms. Lerma?
Yes, Your Honor. Monica Lerma, adult probation. It is, Your Honor.
Okay, so what we have on this, Mr. Parra, is your client basically had very spotty compliance with the treatment, and ultimately, you know, going to about 2018, he never continued with treatment. So the last time I think, if I'm looking, was back in 2019, where he was dropped again. You know, it's a series of starts, and I don't want to say blow off. I don't want to characterize it like that, but constant being dropped from treatment.
Clients otherwise.
Sorry, Mr. Parra, it's real hard to hear you. I don't know if there's something funny going on with the audio there.
I'm in your court, Judge. I wouldn't know what to fix.
Okay, yeah, maybe I don't know, maybe is the laptop volume all the way up? I don't know that affects it, but
I don't know if it would make a difference, Your Honor. I did just raise the volume on it. I'll speak more loudly, as long as it's known that it's not.
yeah, go ahead. What I'll tell you, okay, so it was in reviewing these cases, all of this non-compliance comes to light. He's not had a positive drug test. Other than that, let me see. However, he only provided one UA in a year. Ms. Lerma, was there, in addition to this, failures to report other than not being compliant with treatment?
Your Honor, since being placed on probation June 3rd of 2014, he's only managed to complete 93 and a half hours of the original hours ordered, leaving him with a balance of 106 and a half hours. A lot of his court costs and probation fees are outstanding. The day we picked him up on the bench warrant, Your Honor, we did do a financial. That was one of the first times that I talked to him, or the second time. We did a financial, and his financial situation's pretty rough, is what we found out. We were subsidizing when he would attend the little that he attended treatment. We're willing to work with him if he's committed to actually completing treatment, but we would ask for a 2-year extension so that he can do that.
And Your Honor, I understand that he has come short on a few things. Ms. Lerma is correct in that his financial situation has been one of the larger bars in keeping him completing everything, specifically the financial conditions. But I think his compliance otherwise, the fact that he's never had a dirty test, go to show that he is taking it seriously. Judge, I would not characterize him as blowing anything up when it comes to his probation conditions, Judge. If it takes an extension, I know Mr. Mejia will get out there and do what he needs to complete what he has to, Judge.
Yeah, but he hasn't done it in, is it 9 years?
Well, Judge, if
9 years?
he hadn't completed any conditions, I'd be agreeing with you. However, again, that's not the case. he's complied largely otherwise, Judge. And again, I think now, hopefully, with his financial situation stabilizing and the fact that we no longer are running into these COVID-caused unavailability when it comes to community supervision opportunities, Judge, I realized that he was not completing hours before that, but it's my understanding that his efforts very recently anyway ran into that wall. Judge, but given that extension, I know that he was complying, and of course, we can keep this motion hanging over his head. But I think the judges, instead of asking him to post bond, we have him pay some of those outstanding fees, treat that as a bond, Judge, allow him to get out, continue the treatment, given this extension, and just keep the motion over his head, Judge, if we need to.
Ms. Lerma, I'm looking at the portion of the case summary regarding reporting. And he's supposed to be reporting twice a month.
Correct, Your Honor. Yeah, I did.
So I'm looking at what is listed as the failure to report dates. And I see March 15th, March 24th of 2022, March of 2021, February of 2021, May 26th, and May 28th of 2021. What I want confirmation of is probation telling me that for 9 years, he was reporting, even though he wasn't doing the treatment, he was reporting, but for the 1, 2, 3, 4, 5, 6 dates that are listed there.
Pretty much, Your Honor. That is what I found. Those were dates that he didn't look like he logged on to Teams when we were doing the video reporting, is the documentation that I have. And I continue looking forward to see if that was made up at some time. And those were the dates that were missed, that were not made up.
So are you telling me from 2014 to, I'm going to say right before COVID, right? 2019, he always reported?
That's what I see, Your Honor, in looking at the notes. That's what I can tell.
Okay. See, now that goes a lot further than some of this other stuff. Okay, Miss Elizalde.
Judge, I do see that the recommendation is an extension, and based on the fact that he has been reporting and he has no new charges at this point, if the court wants to, I don't see an issue with trying to work with him in that end, but I did see a note that said that probation needed to be modified for him to see his kids.
Yeah, I was going to get to that one, and let me ask what the conditions are right now.
Your Honor, as far as the conditions go, he's not allowed contact with anyone under the age of 17. He did get married. His wife had a child, and then they had a child together. Now I believe 13 and 9 years old, if I'm not mistaken, or pretty close to those ages. And modifications were never, what I can tell, never submitted for supervised contact. So we would need to submit those modifications as well.
What, Judge, I'm just going to say, we have someone who's not doing treatment, and we're just going to modify him to spend time with kids, given the charge.
Specifically his biological children, Your Honor.
So, well, that doesn't matter. And we knew of these children. One is 13 and one is 9, right?
Yes, ma'am.
And we're thinking that while he was just floating around for 2 or 3 years, not following treatment, he hasn't had contact with these children.
He has been living with them as far as I know, Your Honor.
So he's in violation of his probation. Completely. Is there a rec, Miss Elizalde?
Judge, at this point, the rec would be 5 TDC.
How old is how old was the oh no, it is. How old was the victim?
Just a moment, Judge.
She was 13.
13.
Nope. Do we have a motion?
We do have a judge, motion file, Judge, because he's coming, he's gonna be expired soon, I think, if we just left it that way.
Mr. Parra? No, I am not in agreement with the limited. Basically, he's kind of done regular probation. And no. So if you want to have a contested rebel, happy to do it.
Understood, Judge.
Okay, I'm gonna set him for 30 days for a probation status. If you want to go rebel route, we can speed it up if that's helpful, Mr. Parra, but we'll take your cue.
Your Honor, with respect to any kind of treatment, would you consider any program that would not allow him to be released?
Mr. Parra, you're saying any program that what?
Would require his, or well, that wouldn't allow for him to be released, Judge, as a condition of probation.
If you have alternate ideas, we can talk about them in 30 days and see where we are. I'm really not there. But he hasn't picked up any new, well.
See, that's my thing, Judge. There's no new offenses and again.
Yeah, but he hasn't been doing his probation. He has not been supervised as a sex offender. And he's been having contact with children. And he has not made the effort to do treatment in 10 years. You don't get to just blow it all off, which I will characterize it like that, except for the part that really doesn't, raise eyebrows. I'll keep reporting to my probation officer, but I'm not going to be scrutinized. He's been around a 13-year-old and a 9-year-old while he has not done his treatment. And 9 years into his probation, we're going to modify him. Yeah. Mr. Parra, when does he term?
June of next year, Your Honor, June 20th.
Okay, so we'll do March 28th and we'll do it at the 3 p.m. docket. Thank you very much.
Thank you, Your Honor. May I be excused?
You may. Who's next?
Bottom of page 19, Judge. Annex, may we have Barraza? Sergio
Yes, sir.
Barraza.
Give me 1 second.
Thank you.
Alyssa.
This is Russell Abud. You might as well have Corral because they're co-defendants.
Are you representing both of them?
Yes, Your Honor, they're brothers. From the same mother.
So we don't have any issues here. I don't know about the cases, but
Well,
have any conflicts?
if it ever goes to trial, there might be, but I don't believe so. We've been before the court.
Where is
Sorry.
Mr. Corral?
Annex, may we also have Mr. Corral, Andres?
Judge, the issue of this case is that these two brothers were not the shooters. There's a third brother who just passed away on Monday. And I have shown the police officer his confession to the crime and his possession of the weapon. And I've been trying to get hold of Mrs. Elizalde, who doesn't know how to call back, but that's okay.
Oh, let's be professional, please. Go ahead and call the cases, Mr. Marufo.
Cause number 2022-0D01962 and 2022-0D01961, State of Texas versus Andres Corral and Sergio Almanza Barraza. Announcement of council, please.
Aliana Elizalde for the state. State is ready.
Russell Abud, on behalf of both defendants, we're ready.
We are scheduled for bond hearings in each of these cases. They are both set, if I'm not mistaken, at 300,000. I'm not sure if those are split. I believe Mr. Barrazas is split 150 cash surety, 150 PR. I'm not sure if Mr. Corrales is split same, but Mr. Abud, you may proceed.
As I would say, Judge, that's our only, we've been before the court twice prior to today on the bond reductions. And that is our issue here. The officers agreed with us. that they were not the shooters. They did not have possession of the weapons. It was the third brother. And the officer saw the video of him dying in the hospital bed. And these two brothers just want to be able to go to the funeral. And they can't afford the bonds. And they're basically saying they weren't the ones who did the shooting. They have no records, US citizens, lifelong residents of El Paso.
Anything else on the bond?
Not right now, no.
Okay. Ms. Elizalde?
Judge, first I do want to say, this is the one where he got on and said it was an emergency, and I had called him back and we had discussed it. There was a transition in chiefs, and my chief, who is the one who should be making this decision, did call Mr. Aboud and left a voicemail for a callback. So I do want to put that on there. I do not disregard calls.
Yes, sir.
That being said, Judge, Mr. Aboud had discussed this with me. I think the position that we're taking is, and I'm not going to speak for detectives, but there wasn't a situation where they were like, we know he's innocent. They were following up on a lead, and I spoke to the detectives at one point, and they told me they wanted to talk to him. At that point, Mr. Aboud had said, well, we want probation, right? And that doesn't sound to me like that was represented, that if we got this guy's confession, he would like probation on these cases. And that is my recollection of events. So what we have here is we have a photo lineup done. We have 2 victims that are cooperating. This all happened at a bar. We would have them through the law of parties from some of the actions that we see here, and there was a photo lineup. And so what we're seeing here is we have someone who unfortunately, and I don't know how there's no good way to say this, but he has passed away, taking the blame for his brothers. And I don't know that really changes the case, right? If you have a confession, give it to the detectives, they can give it and we can consider it. But at the end of the day, we did try to reach out, Mr. Aboud, and that's the state's position on bond. We object to it.
Are both those bonds split 150, 150, Marissa, on both defendants?
It's a 150 per count. So yes, it comes out to 300. They're at 300,000 because it's 150 per count of ag assault with deadly weapon.
Okay, and I was looking at, that was Judge Pretty's bond order, was it not? So,
Yes, ma'am.
So the total is per individual is 300,000, right?
Yes, Your Honor, 75
Perfect.
cash or surety, yes, per victim, and then
Okay.
75 PR.
So each of these bonds is $300,000 split 150, 150.
That's what I understand, Judge, yes.
Yes, Your Honor.
Okay. The
Judge,
request.
sorry, Judge. I just wanted to mention briefly on Andres Corral. He does have a record, 2015, concealing goods for illegal export with the feds, felon in possession of ammunition, 51 months. So he has a prior pen trip, and looks like a smuggling case, but I'm not exactly sure if I want that.
And both of these are set for trial on March 17th, right?
That's correct, Judge.
Yeah, the request for bond reduction is denied. The bonds are appropriate. Thank you very much.
Thank you, Judge.
Okay, who's next?
Bottom of page 20, Judge.
Mhm.
Annex, may we have Crystal Herrera?
Good afternoon, Your Honor.
Good afternoon, Mr. Hernandez.
Your Honor, I wanted to request, I'd mentioned it to the office yesterday, but they said to bring it up with you today. My client would like to do an in-person hearing. We have both witnesses and evidence, so we'd like to present at that hearing. So could we get a reset for in-person?
Sure, we can do a reset in 2 weeks. I will tell you that there is one additional case, I think ending 0353, that we need to add to that as well. So we can do an in-person in 2 weeks. 28 will get us to the 14th of March. Am I figuring that out right? We can do it at 1:30 in the afternoon.
Thank you, Your Honor.
Okay.
You said 1:30?
Yes, sir.
Thank you, Your Honor. Am I excused?
You are. Thank you, Ms. Herrera. Who's next?
Bottom of page 21, Judge. Annex, may we have Jose Zubia?
Yes, sir. Give me 1 second. Yeah.
What's Mr. Zubia's bond?
Judge, he has 3 cases. 2 are filed. The filed cases total 16,000. The unfiled is 5,000.
What's the unfiled case?
It's a PR bond revo unauthorized use from May.
Okay, go ahead, Mr. Mon.
In cause number 2023 0D0 0455 and 2023 0454, State of Texas versus Jose Alonso Zubia. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Rick Huffman on behalf of Mr. Zubia, we are ready.
All right, Mr. Zubia is appearing from the jail annex. We're scheduled for bond hearings on 2 cases. Unauthorized use and evading of the vehicle. Mr. Huffman, you may proceed.
Thank you, Judge. Your Honor, we're respectfully requesting the court consider a PR bond in these cases or a bond reduction. Mr. Zubia is 24 years old, Judge. He is a U.S. citizen. He currently lives here in El Paso with his mom. I have confirmed that. I've spoken with her, and I do have an address for the court. He is a lifelong resident of El Paso, with the exception of some time he did in TDC, and he worked in the oil fields for about a year. Judge, he works as a diesel mechanic. So he thinks that there's a good potential for employment if released. He has a 6-year-old son that he sees often and who he supports as much as he can. Your Honor, he was out on a PR bond for an unauthorized use. He was released back in May of 2022. And from it's my understanding, Judge, that he was reporting and complying with the terms and conditions of the PR bond. Your Honor, on these allegations, obviously it's still pretty new. He's been in jail for about 45 days. But I do think that the identifying Mr. Zubia as the driver is going to be an issue for the state. It's my understanding that the only thing identifying Mr. Zubia is the co-defendants pointing their finger at him. I'm sorry, not even the co-defendants, but people that actually were in the vehicle who identified Mr. Zubia, but police never saw Mr. Zubia in the car. Judge, we're hoping the court will consider a PR bond. Right now, Judge, the family, the friends and family might be able to afford the bond if the bond is basically cut in half. So in the alternative, we're asking the court to consider reducing the bond and allowing Mr. Zubia an opportunity to get out and work and basically continue on his PR bond. Thank you, Your Honor.
Ms. Elizalde?
Judge, we would object to a modification or PR bond. I understand Mr. Hussman's concerns about ID, but it was the victims who saw him driving their truck, and they followed him before officers told them to disengage, and they were able to identify the defendant as the driver of the vehicle. And then when the co-defendant was found driving the vehicle, she told them where he was, and he was taken into custody. So, you know, as long as we have the victims on board, we really don't have an ID issue here. The other thing I want the court to know is he's not even probation eligible. just kind of going over his record. I do apologize, my he
So
has a prior pen trip, Judge.
Mhm. So
And
the total amount of bonds here is how much?
So Judge, he has 10,000 on the evading,
Mhm.
6,000 on the unauthorized use, and then 5,000 on the unfiled unauthorized use case.
All right. I'm pretty comfortable with those being appropriate bonds here. So the request for a reduction is denied. Okay,
Understood, Your Honor. Thank you, Your Honor.
thank you very much. Who's next?
Judge, that is it for now. Mr. Kennedy has not logged in. I
Okay.
left him 3 messages, Judge, this afternoon.
Yeah, did he receive notice? We can go ahead